starting with the fact that I was not provided with, nor did I have an opportunity to examine all of the documents, photographs, and other paperwork that the prosecution intended to produce against me at trial, despite my request per MCR 6.201. I was not provided with the opportunity to inspect all tangible physical evidence that the prosecution intended to produce against me at trial, despite my request per MCR 6.201. I was not provided with any criminal record of all the witnesses the prosecution produced or intended to produce against me, despite my request to the same MCR. This list continues further, but in short, I was not allowed the opportunity to properly prepare my defense due to the lack of information in the discovery with which I was provided. I do not know why I was not provided with this information, but the why does not change the fact that my requests for information that I had every legal right to were completely ignored. And this brings me to the subject of Michael McCarthy, my court-appointed attorney, and I would like to thank you, Michael, for the things that you had to say on my behalf. They were very kind, but unfortunately, I also do have to bring to attention, I do have to bring to attention that I'm not satisfied completely with the counsel that you have provided me. I believe there were many things that should have been done that weren't. As Michael McCarthy said, he and I have met countless times over the course of this case where I expressed my concerns and expectations involved in my defense. Unfortunately, these expectations were not met. I presented Michael with the names of witnesses who I wished to be called to testify on my behalf at trial, and to my knowledge, Michael did not so much as interview these individuals, and my request went ignored. During our meetings, I brought to Michael's attention numerous points that I wished for him to present at trial, and despite his assurances to me at the time, he neglected to address many of these issues. Among these were the defenses that I requested that he present. These included abandonment, claim of right, duress, and the mere presence defense. Of the 4 defenses that I found to apply to my circumstances, all of which were agreed to at the time of my request, only mere presence and duress were presented. When I questioned Michael on this at trial, he remarked to me that at that time nothing could be done about it. In doing this, he impeded upon my constitutional right to present my defense. No witnesses were called in my defense. My requests for various types of expert witnesses went ignored. No defense exhibits were prepared whatsoever for the jury. Witnesses were not confronted on multiple contradictions and inconsistencies that were present in their testimony, points that I practically harped Michael on that were key in my defense were entirely neglected, and timely objections were not made where they were due. It is for all of these reasons compiled together that I submit that I was not given effective assistance of counsel. I'm not trying to beset in any way Michael McCarthy's reputation. I'm not trying to say that he isn't a good attorney. He's very experienced, and he is effective, and the arguments that he presented were very persuasive. But what I am saying is guarantees and assurances that were made to me by him were not fulfilled, and the needs of my defense were not met. Now to broach on the aforementioned inconsistencies in witness testimony. The first witness the prosecution produced was the female operator who received Tanner Cipriano's 911 call. By her own testimony, she stated that her recollection of the call was fuzzy, and that it was difficult to hear the caller because he was whispering. Despite this, she was able to confirm that the recording was true and accurate. Beyond that, she confirmed that transcripts were a true and accurate representation of the recording. I failed to see how, if her memory is fuzzy, her word, that she could confirm with a 100% certainty that the recording and transcripts of the recording were true and accurate, especially considering that because the caller was whispering, it was difficult to hear in the first place. I brought this point to my attorney's attention, and he neglected to address the issue at trial. In fact, he refused to cross-examine the witness whatsoever. Now to talk about Ian Zinderman and his testimony. Every time this man has said something, it has been changed. His preliminary examination testimony was so inconsistent and contradictory that it would have been comical had the implications of his statements not been so grave.